Njoroge, and yes, for the next couple of hours, we shall be letting you know of exactly what is happening in the country, the region, and beyond. This morning, senators are in Kitui County for their Senate Mashinani edition number 2, and a lot of issues are expected to come forth from this particular county. Yes, last week we had a sitting with the Senate Speaker, that is Ken Lusaka, and he promised a lot of the issues that are challenging devolution will be discussed at length when they will be in Kitui. It's also a day that the courts will be quite busy. A lot is happening from the corridors of justice, and we shall make sure that each and everything that will be developing from that end, you are well updated. Your voice, your participation on this show is much appreciated, so kindly hit the hashtag K24 Daily Brief online. You can find us at K24 TV, at Sam W. Njoroge, at Shiksha Aurora, who, by the way, will be not with us for this week, but she will be joining us come next week. However, for now, let us brace this show and run it by giving you what is currently developing as of now. The top stories as far as our news diary is concerned, where Sarah Wairimo, the widow of the murdered Dutch tycoon, that is Top Cohen, is due in court this morning to take plea to the charge of murder alongside another suspect arrested on Friday. Now, the two suspects will appear before Lady Justice Jessie Lesit, who heads the High Court Criminal Division, and meanwhile a post-mortem on Cohen's body, which was retrieved from an underground water tank on Friday, will be conducted today. Now, from IEBC, we've got the Dispute Resolution Committee expected to give its verdict on whether or not football star McDonald Mariga will run in the upcoming Kibra by-election. Mariga petitioned the IEBC after Kibra returning officer, that is Beatrice Muli, invalidated his nomination on grounds that his name was missing from the register of voters. And you remember that issue on the Division of Revenue ruling? Well, this morning, the Supreme Court will give its advisory on the legal issues arising from the Division of Revenue Bill 2019. The Council of Governors had sought the court's intervention following a standoff between the Senate and the National Assembly. The Senate has since ceded ground and accepted the proposed 316 billion Kenya shillings contained in the republished Division of Revenue Bill, currently before a mediation committee from the two houses. And also today, judges resume work after a month-long recess. Now, during the August vacation, a duty judge was stationed in every division to deal with urgent matters only. Now, during the break, the judges held their annual colloquium themed Balancing Judicial Independence and Accountability. And last but not least, today is the International Day for Preservation of the Ozone Layer, as designated by the United Nations General Assembly. The day commemorates the date in 1987 on which nations signed the Montreal Protocol on substances that deplete the ozone layer. So as of now, some minutes past the hour, those are the stories that we are giving priority right here at K24 TV. The diary is bound to change in the course of a time, but we shall be right here to ensure that we update you each and every time we get an update right here in as far as our news diary is concerned. However, we told you this morning that Sarah Wairimo Cohen is being arraigned in court to take plea on murder charges, and that has already happened. So let's cross over to court and ensure that we get this event as it continues developing right now. And those are the proceedings that we are getting in court. So let's cross over to Milimani Law Courts and listen in.
Against the defense. Plea cannot be taken without mental assessment of the accused person. It was not done over the weekend. It is not late. And the defense has also us to be present when the same is being done. That is a mental assessment, which we have no objection to. I am informed that there has to be a booking and an arrangement with the doctor to do the assessment. We want the defense to be part of this so that they don't miss out during the mental assessment. As regards the PM, we have received a letter making a request that Professor Andrew Kanyigashi be present for the defense when the PM is being done. Well, the PM was supposed to be done at 2:30 p.m. I have taken instructions and consulted the investigating officer. We have no objection to Professor Andrew Kashi being accommodated, because that's the best thing to do, so that he can be present tomorrow. I will not say at 9 because the parties have to agree. That is the doctor for the defense and the chief government pathologist as regards time, so that each party can carry the exercise within their convenience tomorrow. Lastly, my lady, senior counsel has actually argued bail. I don't want to respond to his arguments on bail because he was arguing release on bail holding a document he's supposed to serve me, and he has shown to the court.
I haven't filed it.
Filed?
I haven't filed it.
It makes even matters worse. It's not filed. But if there are intentions to file it, let it be filed. Will be served. We need to respond. And I made it very clear, my lady, that we have an obligation under Article 49, 1H. It's about Article 1H. To demonstrate to this court whether there are compelling reasons to deny the accused person bail. We also have his obligation under Article 157(11) of the Constitution. So, my lady, we want this opportunity to be given to us. We canvass bail. We file the necessary affidavit. And I must say from the onset that bail will be opposed. So I go back to my earlier prayers that the accused be taken for mental assessment when we come back before you, and you give us a date when we can canvass bail. That's all, my lady.
My lady, the family, they are present in court. We are ready for the postmortem at 2:30 p.m. today. And the family had a doctor ready, a pathologist ready by the name of Professor. But having listened to both sides, that is the prosecution as well as the defense, we will be conceding so that we can be able to have that postmortem done tomorrow. But as regards the issues of bail, I object. Your Ladyship,
Can I sit both of you down because the matter is not before the court yet?
I just wanted to say that on matters of that postmortem, I was quite happy to have the family state their position, but on all other matters,
Now, the late Top Cohen's best friend, former Gatundu North Member of Parliament, that is Patrick Kariuki, had said a lot in as far as this issue is concerned. He also intimated that the wishes of Top Cohen were that he be buried after 48 hours. Will that happen? Because now the case is ongoing and a post-mortem is due. So we will keep monitoring all these events and we shall run them by you as and when we get updates in as far as that story is concerned. Now, around a month ago, we had a directive from government, courtesy of Cabinet Secretary Transport, that is James Macharia, and he said that there will be a bit of inactivity when it comes to transport of cargo with trucks, and instead there was that directive that SGR to be taking over this particular mode of business. However, we've had truck drivers over the last 1 month weigh in on this matter. Some are quite literally uncomfortable with this directive. And this morning, we've got our correspondent, that is Boniface Musangi in Mombasa, who's been following up on this story and now joins us live with an update from County 001 on what truck drivers are saying in as far as this directive is concerned. Let's listen in.
Thank you very much, Shiksha and Sam, here in Mombasa today. There are demonstrations whereby the transport sectors and business community have just assembled here to demonstrate opposing the mandatory transportation of cargo through KPA, through the SGR, whereby they say the transportation will deny them their rights. Also, the transportation has made them to their business to go down as they cannot use their trucks to move the goods from Mombasa to Nairobi. Here with me are just a section of the transport sector. Just karibu kidogo utueleze kwa majina yako, tuambie wewe unaitwa nani na why are you demonstrating today?
Kwa majina mimi naitwa Salim Karama. Sisi ni wafanyaji biashara wa transport hapa mjini Mombasa. Tumetegemea ama tumeongoja viongozi wetu ili watutetee kuhusiana na mambo ya SGR. Mpaka dakika hii hawakuweza kututetea. Kwa hivyo tumejitokeza sisi, hapa hakuna mwanasiasa ama nini. Tumejitokeza kama wafanyaji biashara ambao tuliodhurika na hii mambo ya SGR. Wafanyaji biashara kila aina ambao wamedhurika hapa, paka kina mama wa kuuza mbaazi, wafanyaji kazi wa tuktuk, biashara nyingi sana zimekufa. Mombasa imekufa total. Imebidi sasa kimya chetu, karimu wetu, imebidi sasa jipu litumbuke ili tupeleke message kwa rais ili atambue kwamba madhara makubwa yako katika mji wa Mombasa.
You have not told me your points. What's your demand to the government, or what are you expressing today?
Sisi twa demand kwamba rais kama natusikia saizi, hii ni demand. Tuataka aachilie biashara iwe huru. Wafanyaji biashara ama importer ambao wanaleta container zao, wao wenyewe wajiamulie. Sio kwamba serikali hii ni ukoloni mambo leo. Kwa hivyo tuamwambia mtukufu rais, tafadhali wachia mwenye biashara mwenyewe aweze kuamua nini anataka kufanya, lakini sio kulazimisha.
Thank you very much. Here with me is another lady, a stakeholder. Just tell us your name and why have you decided to come here today and demonstrate?
No SGR, no road transport, no SGR, no road transport, no SGR. Speak. No road transport, no SGR.
Okay, kitu yenye mimi nitasema, before SGR iwepo tulikuwa tunafanya biashara vizuri. Mi for example nitasite upande ya clearing and forwarding, because nilikuwa nafanya kazi ya clearing and forwarding. Nilikuwa naweza kuclear ma container na clear gari na napata livelihood. Lakini since SGR itokelezea, biashara yote imeenda Nairobi. Let's cite for example kitu ya kwanza, kama ukiangalia from hapa Malituko Changamwe, uondoke kutoka hapa paka Jomvu, ukifika Jomvu utashangaa maana petrol station zimelala, spare parts zimelala, watu wa clearing and forwarding walihama. Ukiangalia nyumba ambazo tunaishi, kama mimi nimerent nyumba, sasa tunadaiwa kwa sababu hatuko kazi. Zamani tulikuwa tuko kazi, tulikuwa tunaweza hata kusaidia parents wetu, tulikuwa tunaweza hata kufanya kulipia NHIF, NSSF. Sasa hizi tumeweka tu kama tuseme kama karatasi ile ya kawaida, iko tu kwa wallet, hatujalipia, tunadaiwa kwa sababu hatuko kazi. Mimi nitasema kitu kimoja kwa mtukufu rais. Tulikuchagua, lakini tukukuchagua uweze kutunyanyasa watu wa Mombasa. Kwa sababu kutoka ulileta SGR, kitu ya kwanza hatujui SGR ilinunuliwa pesa ngapi ama ilitengenezwa na pesa ngapi, kwa sababu sisi tu hiyo imekuwa ni siri. Second thing, mbona sisi watu wa Mombasa ndo tuwe tunalipia kitu ambayo haitufaidi? It is impossible wewe kuchukua rasilimali ya mtu wa Mombasa unapeleka kwa kaunti nyingine ambayo ni tajiri. Niseme hivi, mtukufu rais, kumbuka kwamba Mombasa pia ni county kama ile nyingine. Lakini kama utaweza kutueleza sisi si wa Kenya, tujipange, tuko tayari. Lakini kwa sasa tunajua sisi ni wa Kenya. Tuko na ID, tuko na NHIF, tuko na NSSF. Lakini kwa sababu umechukua rasilimali, huduma namba tulichukua, tumehesabiwa census. Kwa hivyo sisi ni wa Kenya. Lakini kwa nini mbona unachukua rasilimali yetu unapeleka kwa nchi ambayo ni county ambayo ni tajiri already? Sisi hatuna mashamba ya kulima. Sisi tuna hiyo rasilimali. Mungu akiumba Mombasa aliumbia bahari. Unaona, sasa kama utachukua bahari ambayo ni ya Mombasa upeleke kaunti nyingine, una expect nini? Mombasa wafanye nini?
Thank you very much. And perhaps just shed more light on this question. What's your take on that?
Naam, sisi tuko hapa pamoja na wakazi wote wa Mombasa. Tumekuja kuonesha umoja wetu kwamba tunapinga hizi sera ambazo zinatekelezwa na serikali kuu, na pia tunapinga hatua ya kufanya SGR kuwa na monopoly katika hii nchi yetu hapa Kenya. Kama wananchi wa Mombasa, sisi ni wa Kenya kama wa Kenya wa kule Embakasi, kama wa Kenya wa kule Naivasha. Hatuwezi kukubali kabisa sisi kunyanyaswa, sisi kuonewa, kudhulumiwa eti kwa sababu tunataka kulipa wa China. Hiyo hatuwezi kukubali kamwe. Sisi tunawaambia wakazi wa Mombasa, musikubali, na a call to mass action is hereby being sounded out. Katiba katika kipengele cha 37 kiko wazi kwamba tuna haki ya demonstration, tuna haki ya kuprotest, tuna haki ya petition. Na leo hii tukiwa tumeungana mashirika, transporters, bodaboda, matatu, petrol station, all Mombasa residents who are affected, hatutakubali maoneo haya yanayoendelea katika Mombasa hii. Na wale viongozi ambao wamenyamaza tu, tunawaona na tunawaangalia. Wananchi wanakosa school fees, wananchi wanakosa rent, wananchi wanakosa chakula, insecurity imezidi na viongozi wananyamaza tu. Hakuna kitu wanafanya. Kwa hivyo tumesema wananchi, mujitokeze nyinyi wenyewe. Hakuna viongozi wa kuwatetea. Mujitokeze, mudai haki zenu. Hatutakubali mambo haya kuendelea.
Thank you very much. Let me just have the last person here who will shed light on this matter.
Jamaa, sawa. Basi kwa hakika okoa Mombasa, mambo imeanza. Mambo bado. Sisi kama Wakenya wote tukasirike na tumekasirika. Haiwezekani monopoli ya SGR na tunaangalia kama mashirika na transporters na wenyeji wote wa Mombasa. Leo ni kionjo, tumeanza, na licha ya hapo tutatumia all legal means. Tutafanya maandamano, tutaenda kotini, tutafanya njia zote na Mombasa tutaiparalize. Kwa hivyo Uhuru Kenyatta, tunakuambia reverse your decision. Macharia, tunakuangalia. Mombasa ni yetu. Hivi sasa vijana hawana kazi kwa sababu ya SGR kubeba mizigo yote. Matransporter wameenda nyumbani, mitaani insecurity imezidi. Hii yote is because of bad governance, bad decision. Hatuta allow. Kwa hivyo okoa Mombasa, tuko macho na mambo bado. Leo ni kionjo, tuko ngangari. Asante, bismillah.
Thank you very much, Shiksha. Thank you very much, Shiksha. And from Mombasa, I just hand you over back to the studio.
On behalf of Shiksha Boniface, we thank you for that link live from Mombasa. Straight on, let's take you to Anniversary Towers, listening to the Disputes Tribunal that has been listening to the petition that was lodged by MacDonald Mariga.
The background of this, on 14th of August this year, that is 2019, by the notice sent
You want us to move this way?
Oh,
okay.
okay.
Oh, good.
Okay.
Oh, good.
This thing's working.
Okay. Yeah,
okay, it's working. Okay. Now the background of it, on 14th of August 2019, by notice sent to the IBC by the Speaker of National Assembly on 13th of August 2019, the Kibra constituency parliamentary seat was declared vacant following the demise of the area MP, Honorable Ken Okot. Upon receipt of the subject declaration of vacancy, the Commission, in exercise of its mandate under Article 88(4) of the Constitution, issued a notice for a by-election in the Kibra constituency to be held on 7th of November 2019 by the special issue carried in volume number 106 of Kenya Gazette, published on 16th of August 2019. The Commission reserved in the said Gazette notice the 9th and the 10th September 2019 as date for registration of candidate for the by-election. On the 10th September, the complainant, hearing MacDonald Mariga Wanyama, presented his nomination application as duly nominated candidate for Jubilee Party to the respondent, in order that he may be issued with a notice, with a nomination certificate as a candidate for the position of Member of Parliament for Kibra constituency. His application was rejected by the respondent on account that the complainant was not a registered voter and therefore did not meet the requirement for qualifications as a Member of Parliament as set out under the law. Dissatisfied with the respondent's decision, the complainant lodged the present complaint before this committee on 11th of September 2019. The parties to the complaint. The complainant was nominated by the Jubilee Party of Kenya as its candidate for contest of seat of Parliament for Kibra constituency in the by-election selected for 7th of November 2019. The respondent, Beatrice Muli, is a returning officer for Kibra constituency, having been appointed by the Commission in accordance with Section 39A of Elections Act 2011. The first interested party, Jubilee Party of Kenya, is a political party duly registered under the Political Parties Act 2011 and has nominated the complainant to vie for Kibra constituency parliamentary seat. Leina Conchela, a duly registered voter in Kibra constituency, was admitted as second interested party in this proceeding on 13th of September 2019 by the notice of motion application dated 12th of September 2019. His admission to the proceeding followed the committee's ruling on his application herein above, in which he only sought, according to the ground B on the face of the subject application, for leave to be enjoined in proceeding as interested party on the ground that he intended to advance centrality of integrity in the electoral process, and particularly in the Kibra by-election. The application did not seek any other substantive prayers or order. In its ruling on the application, the committee directed the second interested party to limit his representation to the matter under consideration in the complaint, with a rider that any other matter not touching on the complaint should be addressed in a different forum. Consequently, paragraph 12, 13, 14, and 15 of his affidavit in support of the application were expunged from the record. The dispute. The dispute before the committee arises from the respondent's decision of 10 September 2019 rejecting the nomination of complainant as a candidate for the forthcoming Kibra by-election for the reason that the complainant's data was not found in Kenya Integrated Electoral Management System, KIMS. In his complaint, dated 11 September 2019, the supporting affidavit sworn on the same date, complainant averred that the respondent's decision was improper, null and void for want of lawful invalidation, since the complainant is a registered voter. Complainant further asserts that he was registered as a voter on 26th of August 2019 at Karioko Social Hall, polling station in Starehe constituency, and was issued with an acknowledgement slip bearing electors number 0145-211-90826-1205-9. It is his contention that he met all the requirements of the nomination as was confirmed by the first interested party in its replying affidavit sworn by Andrew Musangi on the 13th September 2019. On the account of foregoing, he praised at paragraph 7 of his complaint that this committee should make a finding that the decision of the respondent is void and of no legal effect, and that it be determined that the complainant was validly nominated by a political party, that is Jubilee Party of Kenya, and his nomination affirmed by the issuance of certificate of nomination by the Commission for the position of member of Kibra constituency. The jurisdiction of this committee. The jurisdiction to hear and determine dispute relating to or arising out of nomination is donated to the Commission by Article 88, Sub-Article 4E of the Constitution, Section 74 of Elections Act, Regulation 99 of the Election General Regulation 2012, as well as the rules of procedure and settlement of dispute. To this end, Article 88(4)(e) of the Constitution provides that the Commission is responsible for conducting or supervising referenda and election to any elective body or office established by this Constitution and any other elections as prescribed by the Act of Parliament, and in particular, Section Sub-Article E state that settlement of election dispute, including dispute relating to or arising from nomination, but excluding election petitions and disputes subsequent to the declaration of election result. The above provision is replicated under Section 74 of Elections Act and Section 4 of Independent Electoral and Boundaries Commission Act 2011, which outlines the function of the Commission. Thus, pursuant to Article 88, Sub-Article 4E of the Constitution, the Commission shall be responsible for settlement of election dispute, including dispute relating to or arising from nomination, but exclude election petitions and dispute subsequent to the declaration of election result. Under Rule 2 of the Settlement of Electoral Dispute Rules, the term dispute has been defined as a complaint, challenge, claim, or contest relating to any any stage of the electoral process, includes an objection to the acceptance of nomination papers of a candidate by returning officer. The purview of the complaint under Rule 9 extends to the complaints relating to whether the candidate has all qualifications required under the law, under any law. In the case of Diana Kedi Kilonzo and others versus IBC, and 10 others, the court stated at paragraph 94 of the judgment that a reading of Article 88(4)(e) of the current Constitution and Section 74 of the Act clearly shows that IBC has powers to settle dispute, including nomination dispute, other than election dispute, dispute arising or subsequent to declaration of result. The mandate to settle dispute, therefore, runs up to the election date. The committee hence had jurisdiction to hear complaint of the interested parties. Guided by the above provision of the law, we are satisfied that the committee has jurisdiction to determine the present dispute. We now proceed to consider laws applicable to the resolution of the dispute. The applicable laws. Article 38(1) of the Constitution guarantees the right of every person to exercise their political right, which includes the right to A, to form or participate in forming a political party, B, to participate in activities of or recruit members for a political party, or to campaign for a political party or cause. Additionally, 38(2) provides that every citizen has the right to free, fair, and regular election based on universal suffrage and free expression of the will of electors for any elective public body or office established under this Constitution, or any office of any political party of which the citizen is a member. In order to exercise the right, it is the right of every person to be registered as a voter or to vie for a public or political office. Thus, under Article 38(3) of the Constitution, every citizen has the right without unreasonable restriction: A, to be a registered voter; B, to vote by a secret ballot in any election or referendum; C, to be a candidate for a public office or office within political party of which the citizen is a member, and if elected, to hold office. The right to participate in electoral process, either as a voter or as a candidate, connotes the basic element of democracy. Justice Mativo, in the case of Ekuro Ekot versus IBC and 3 others in 2017, that expressed himself as follows. At paragraph 82, he quoted Article 38 of the Constitution and stated it guarantees political rights, which include the right to be a candidate for public office. Undoubtedly, the right created under Article 38 in favor of citizens of Kenya to participate in electoral process is integral part, and for the sake of convenience, he called it an element of the basic feature of democracy. In paragraph 83 of his ruling, he stated there are 2 important points to note. First is that the right to participation in electoral process, which will include both voting and standing for election, is part of the basic structure of democratic state, which will mean that restriction upon participation in electoral process can only be justified through a very strong reason and in a way that the core of the basic feature of democracy is not damaged. Secondly, even more importantly, while the right under Article 38 and Article 27 of the Constitution are not absolute right, they cannot be limited except by law, and then only to the extent that limitation is reasonable, justifiable in an open democratic society. Any limitation must be subject to 3-part test. A limitation will only be accepted when prescribed by law. B, when it is necessary and proportionate. C, when the limitation pursues a legitimate aim, namely the interest of the national security, public safety, prevention of disorder or crime, protection of health and morals, and protection of right and freedom of others. The principles for conducting election are set out and 81 of the Constitution. They include freedom of citizens to exercise their political right under Article 38, and universal suffrage based on aspiration of fair representation and equality of vote. The qualifications for one to be registered as a voter are outlined under Article 83(1), which stipulates that 1. A person qualifies for registration as a voter at election or referenda if A. is an adult citizen, is not declared to be of unsound mind, has not been convicted of an election offense during preceding 5 years, and 2. A citizen who qualifies for registration as a voter shall be registered only at one registration center. Article 83(3) further provides that administrative arrangements for registration of voters and conduct of election shall be designed to facilitate and not deny an eligible citizen the right to vote or stand for an election. Commission is obligated under Article 88(4)(a) of the Constitution and Section 4(a) of IBC Act to conduct continuous registration of citizens as voters to undertake regular provision of voters' roll. Section 2 of Elections Act defines register of voters as a current register of persons entitled to vote at an election prepared in accordance with the Section 3 and includes a register that is compiled electronically. It is duty of the Commission to establish register of voters, which under Section 4 of the Election Act comprises of A. A poll register in respect of every polling station, a ward register in respect of every ward, a constituency register in respect of every constituency, a county register in respect of every county, a register of voters residing outside Kenya. Whereas Article 84(a) of the Constitution as read together with Section 4(a) of IBC Act requires the Commission to conduct continuous registration of voters, there is limitation imposed by Section 5 of the Elections Act, which provides that 1. Registration of voters and revision of register of voters under this Act shall be carried out at all times except A. in the case of a general election or elections under Article 138(5) of the Constitution between the date of commencement of 60-day period immediately before the election and date of such election. B. in case of a by-election between the date of declaration of vacancy of the seat concerned and the date of the by-election. Any citizen of Kenya who has attained the age of registration and the age of 18 years, as evidenced by either national identity card or Kenyan passport, whose name is not in the register of voters, shall be registered as a voter upon application in prescribed manner by the Commission. All applications for registration under this section shall be registered in appropriate register by the registration officer or any other officer authorized by the Commission. The registration officer or other authorized officers referred to in subsection 3 shall at such times as the Commission may direct transmit the information relating to the registration of the voters to the Commission for the inclusion in the register of voters. By dint of Section 8 of Elections Act, the Commission is under obligation to maintain an updated register for this purpose. A further obligation is placed on the Commission to regularly revise the register of voters. The process of registration of voters is provided under Election Registration of Voters Regulation 2012 and Election General Regulation 2012, which were promulgated pursuant to Section 109 of the Elections Act. Regulation 13 of the voters registration regulation provides that in respect of the first-time applicant, a person who desires to be registered as a voter shall make an application in Form A set out in the schedule. An application under sub-regulation 1 shall be made to the registration officer for the constituency in which the person wishes to be registered. The application for registration as a voter may be made at any time except on the occasions provided under Regulation 15, namely during the time in which registration of voters and revision of register is not allowed as provided under Section 5 of Elections Act, and during period in which the Commission has suspended applications by way of notice published in Kenya Gazette, as was done by the Commission in respect of Kibra constituency via the special notice Gazette, special issue Gazette notice carried in volume 106 published on 16th of August 2019. Regarding the process of registration, Regulation 13A of the voter regulation provides as follows. 1. A person who applies to be registered as a voter shall present his or her identification document to the registration officer stationed at registration center of his or her choice. 2. Registration officer shall, where applicant is qualified to be registered as a voter, issue applicant with Form A as set out in the schedule. The applicant shall return the duly completed Form A to the registration officer, and the registration officer shall confirm the details in the form and enter them in the biometric voter registration system and the voter's record book. The applicant shall be issued with an acknowledgement slip upon registration. Under Regulation 16.1 of voter regulations, the registration officer to whom an application is made under Regulation 13 or 14 shall consider application and A. In the case of an application for registration under Regulation 13, register the applicant if registration officer is satisfied that the applicant is qualified to be registered. If the registration officer registers a person or makes changes in the sub-regulation 1, the registration officer shall issue an acknowledgement slip to the applicant. Our understanding of the above cited regulation is that a person is only issued with acknowledgement slip after conclusion of registration process, in which case the registration officer must be satisfied that the person has met the requirement of registration stipulated under Article 83 of the Constitution. Even though there is no express provision on the registration of voters, a reading of Section 9 of Election Act and Article 99(2) of the Constitution presupposes that once a person has been declared to be unsound mind, is adjudged bankrupt, or is convicted of an election offense, then the person is disqualified from being a registered voter. Then the question is, what happens if a registered voter is subsequently declared to be of unsound mind, is adjudged bankrupt, or convicted of an election offense? Within the meaning of Article 88(1) of the Constitution, they are not entitled to be registered as a voter or remain on the register of voters. Even then, disqualification of a voter cannot be whimsical and must be on the premise of grounds and procedures set out in Section 9 of Elections Act, which is reproduced here below. Where a person has been adjudged or declared to be of unsound mind, adjudged bankrupt, or convicted of an election offense, and is thereby disqualified from being registered as a voter, then if that person is entitled to appeal against decision that that person shall not be disqualified from being so registered until the expiration of the 30 days after the date of decision or such further period as the Commission may, at request of the person, direct in order to enable the person appeal against the decision. Insofar as ineligibility of person to vie as a member of Parliament is concerned, Article 99(1) of the Constitution stipulates inter alia that one must be a registered voter, who is defined under Section 2 of Election Act as a person whose name is included in current register of voters. The same provision has been replicated under Section 24 of Elections Act on the qualification thus, unless disqualified under Section 2, a person qualifies for nomination as a member of Parliament if the person is a registered voter. Having set down the law which we consider to be relevant, we now turn to the submissions which were made by parties in their support of their rival position. At this point, I will leave it to the chairman to proceed from here. Okay.
Yeah, the submissions of the parties. At the hearing of the complaint, Mr. Ongoya, Mr. Lucy, Mr. Majimbo appeared for the complainant, while Mr. Sigei appeared for the first interested party. The second interested party was represented by Mr. Mbala, while the respondent appeared in person. The complainant relied on his submissions dated 12 September 2019, which were adopted and highlighted orally by his counsels. The gist of the submissions by the complainant is that he was duly registered as a voter on 26 August 2019 at Karioko Social Hall polling station in Starehe constituency of Nairobi County before submitting his nomination papers to the respondent. The complainant contends that he met the requirements set out in Articles 83 and 99 of the Constitution, Section 24 of the Elections Act, and the Regulation 13A of the Voters' Regulations. The complainant further submitted that the definition of a register under Section 2 of the Elections Act is not limited to KIMS, and therefore the respondent's decision to disqualify him was ill-conceived, grossly illegal, and tantamount to taking away his constitutional right due to possible administrative failure and or fault of the respondent and the Commission to upload his biometrics and alphanumeric into KIMS as required under Section 5, Section 5.5 of the Elections Act. In view of this, Mr. Ongoya submitted that the question for determination was whether the complainant is eligible in law to vie as a candidate in Kibra constituency. Making reference to the annexure in the supplementary affidavit, in which there is a remark by the respondent, that's the returning officer, that the nomination of the complainant is invalidated because he has not been found in the register of voters in the KIMS. Council submitted that the committee is called upon to decide whether the respondent was right in law by her decision of invalidating the nomination of the complainant. Council further submitted that under Article 99 of the Constitution, a person is eligible to vie as a member of Parliament if the person is registered as a voter. In the case at hand, Mr. Ongoya submitted that the complainant is the holder of an acknowledgement slip which he had at the time he presented the nomination, papers. The acknowledgement slip bears electors number 0145211908261205-9 and is serialized 0003403985-17. Council also submitted that under Section 2 of the Elections Act, the register of voters includes a register compiled electronically, and that in making her decision, the respondent must have proceeded on the fact that the electronic register is exclusive and not inclusive. Asked by the committee through the chairman on what his understanding of paragraph 90 of the K24 case as regards the issue of the value of the acknowledgement slip, Mr. Ongoya responded that the judgment in the Kilonzo case related to the law as it was in the year 2013 when the decision was made. There had been subsequent amendments to the law as relates to legal notice number 17 of 2017, which then, in terms of regulation 13A of the elections registration of voters regulations, codified the process of registration, and thus, in his opinion, the K24 case as regards the value of an acknowledgement slip would only apply in this instance. Mr. Ongoya further stated that in the K24 case, the only documentation under consideration was the acknowledgement slip, and that there was no other documentation on evidence of registration as in the case in the dispute before the committee. The first interested party submissions were as follows. On behalf of the first interested party, Mr. Sigei relied on the affidavit sworn by Andrew Musangi, chairperson, Jubilee Elections Board, together with their written submissions dated 13 September 2019. It was council's submissions that the question before the committee is one on the invalidation of the nomination of the complainant's candidature by the respondent. Council further relied on paragraphs 5, 6, and 7 of Mr. Musangi's replying affidavit, in which he deponed as follows, and we have replicated the contents of those paragraphs. Council also submitted that the party is aware that registration is a continuous process and urged the committee to review the decision of the respondent as it was made in error. The review, in Council's view, would guarantee the party its right to fill a candidate of its choice. The second interested party also submitted as follows. Mr. Mbala relied on the averments in the affidavit in support of the notice of motion application and submitted that Section 24 of the Elections Act, under Section 24 of Elections Act, one of the qualifications for one to qualify for election as a member of parliament was registration as a voter. It was his further submission that under Section 5(1)(b) of the Elections Act, registration can be carried out except between the date of declaration of a vacancy and the date of the by-election. The Gazette Notice 7378 declared that there shall be a by-election on 7th of November 2019 in Kibra constituency. The seat was also declared vacant. Paragraph N of the Gazette Notice suspended registration of voters and revision of the register. Council further submitted that the complainant made an application for registration 12 days after the seat had been declared vacant, with the consequence that the purported registration was not legal. He also made reference to the definition of an acknowledgement slip under the voter regulations and made a point that the complainant is not a registered voter since he only applied for registration, hence not in the register of voters. He urged the committee to dismiss the complaint. The respondent filed a response to the complaint dated 13 September 2019 and made oral submissions during the hearing. She is the returning officer of Kibra constituency and stated that she is a seasoned returning officer, having presided over several elections and referenda of 2010. On the 9th and 10th September 2019, she presided over nominations of candidates for Kibra constituency and cleared 23, while 3 of the candidates were disqualified, one of whom was the complainant. She stated that under Section 24(1) of the Elections Act, the KIMS kit bears the gazetted register of voters. She was assisted by her ICT team in the verification of the complainant's name in the register. They were unable to find the complainant's name in the register despite all efforts. She also stated that she searched the complainant's details in the register as per details in his national identification card, but could not find the details. Guided by the Election General Regulations 2012, the Elections Act, the checklist, and the nomination guide, she invalidated the nomination of the complainant as according to her, the complainant was unqualified. She also tried calling the party through a number provided by IBC for Jubilee Party of Kenya, but they did not pick. When probed by the counsel for the complainant on whether the complainant was called, she stated that she could not have called the complainant because his party had not furnished the commission with the complainant's phone numbers. Additionally, she was asked to confirm that all those who registered before the declaration of the seat vacant were uploaded in the KIMS, and responded that she relied on the register of voters that was provided to her by the commission, and that as an employee of the commission, she works with the register provided by the commission. She further stated that it is electoral practice that once a political party holds nomination, it forwards the names of the candidates to the commission and details are sent to the returning officer. Aspirants then come to the office of the returning officer to register their contacts. Jubilee Party is not a young party, as it has engaged in elections previously, and they know the practice, yet they did not come. She concluded by stating that the 2017 register of voters in Kibra constituency had 118,000 persons. Registration of officers Stare also testified. Mr. Moses Simiyu, the registration officer, informed the committee that he came with the deputy registration officer Ismail Yassin, who was involved in the case. Mr. Simiyu further stated that he was away from office on the material day and requested that the committee to allow Mr. Yassin to give evidence regarding the process. He then invited Mr. Yassin. Mr. Yassin, the deputy registration officer, testified that the complainant appeared before him on 26 August 2019, sometime before midday. The complainant initially did not have his identification card and had to send for it. The actual registration occurred at 12:05 p.m. The electors number 0141210908261205-9 on the acknowledgement slip indicates the date, month, and time of receipt of application for registration. That is to say, 12:05 denotes the time of capturing the voter's data in the kit. 26 denotes the date of registering the voter, while 108 denotes the month, being August, and 19 denotes the year, being the preceding numbers, being the biometric voter registration BVR kit number. The last number 9 is a random number auto-generated by the BVR kit upon registration. He further testified that the complainant, upon producing his national identity card and upon confirming that the applicant was not in the register, he issued him with Form A for purposes of registering as a voter. The complainant filled the form and his biometrics and alphanumerics and was subsequently entered in the BVR system and the voter's record book. He then issued the complainant with acknowledgement slip. The committee, through the chairperson, upon looking at Form A in the kit, realized that the form which Mr. Yassim had witnessed was not signed by the applicant and sought to know why the form is unsigned. In response, Mr. Yassim stated that he could not assign the blame for the omission of, as this was a common inadvertence experienced during continuous voter registration and mass voter registration. However, in such cases, such omissions would be addressed by calling back the applicant to sign off the form. In the complainant's case, he only realized the omission after the complainant had left the registration office. Mr. Yassim also stated that the registration process in Stare constituency is still ongoing. This was a response to a question by Mr. Sigei. In relation to the question of authenticity of the complainant's acknowledgement slip, Mr. Yassim, in response to Mr. Ongoya's question, affirmed its genuineness and authenticity. Mr. Yassim also produced for the committee's inspection the subject BVR kit, which bore the complainant's biometrics and alphanumerical details. the voter record book in which the complainant is recorded as having been duly registered as a voter number 1759, the IBC counterfoil book in respect of the acknowledgement slip in issue which bore the counterpart copy of the acknowledgement slip. The BVR kit also contained and displayed the elector's number similar to the one in the acknowledgement slip. In a rejoinder to these submissions, Mr. Lucy submitted that the returning officer indicated that the reasons why she invalidated the complainant's nomination is because she did not find details of Mr. Mariga in the KIMS. According to counsel, the checklist used by the applicant indicates that aspirant must be a registered voter, yet the respondent had invalidated the complainant's nomination on the grounds that his name was not in the KIMS. On his part, Mr. Ongoya submitted that the respondent ought to have gone a step further to establish that the complainant had registered in Starehe constituency. Since this was not done, the respondent therefore made an innocent mistake, which the committee is urged to rectify. This is our analysis and determination. From the pleadings on record, the submission by parties and relevant laws, we consider the issue that we are called upon to determine to be whether the complainant was duly registered as a voter. In order to address this question, we first must ascertain whether the complainant complied with the voter registration process as stipulated under the various provisions cited herein above, including Articles 83 and 99(1) of the Constitution, Sections 24 of the Elections Act, Regulations 13A, and 16 of the Voters' Regulations. The complainant claims that he presented himself to be registered as a voter at Karioko Social Hall on 26 August 2019. He was issued with an acknowledgement slip bearing electors number 0145211908261205-9, which he acknowledged in his supporting affidavit. This, we find, is consistent with the testimony of the Deputy Returning Officer of Starehe constituency, who confirmed both the attendance of the applicant as well as subsequent registration and issuance of the acknowledgement slip. Regulation 13A(2) of the Voters' Regulations imposes upon the registration officer the duty to ensure that a person is qualified to be registered as a voter before being issued with Form A for purposes of registration. The foregoing assertion by the complainant was not controverted. If anything, the Deputy Returning Officer's testimony confirms that indeed the complainant presented himself to the registration center at Karioko for registration, whereupon verification that the complainant was not registered as a voter anywhere else and was qualified for registration as a voter issued him with Form A. The complainant duly filled the form as required, and his biometric and alphanumeric details were entered into the BVR kit. Following this process, the complainant was issued with an acknowledgement slip as envisaged under Regulation 13A of the Voter Regulations. The authenticity of this slip has not been questioned by any party. The Commission has looked at the acknowledgement slip, which the Deputy Registration Officer confirmed to be authentic. In addition, the committee looked at the complainant's details in the BVR kit and was satisfied that the elector's number on the acknowledgement slip and as shown in the BVR kit matches. It's our finding that under Regulation 13A(3), the complainant was duly registered as a voter and subsequently issued with acknowledgement slip. Indeed, and by way of comparison, the process of voter registration in South Africa is similar to the one in Kenya, to the extent that once a person fills his registration details, which are accepted by the registration officer, that person is considered to have been registered as a voter unless, for the case of South Africa, that person is formally notified of the decision to reject registration immediately. In the case of South Africa, Voter Registration Regulations 1998, pursuant to Section 100 of the Electoral Act 73 of 1998 provides for the registration of voters. Section 2 of the regulation specifically provides for a step-by-step registration process. It says the applicant must in person submit the completed application form together with his or her identity documents to a registration officer at a place identified by the chief electoral officer within the voting district or in respect of the voting district where he or she is ordinarily resident. Every registered political party is entitled to be represented by an agent duly authorized thereto in writing by the party concerned on a form similar to Appendix 3 at a place referred to above. In every case where a registration officer refuses to accept an application for registration as a voter, such a registration officer must immediately complete and hand over to the applicant a notification of refusal in a form similar in Appendix 4. In South Africa, therefore, an applicant whose registration has been rejected leaves the registration point knowing that they are not registered, which is expressly filled and handed over to him. In analogy, it follows that once an applicant has gone through the procedure set out in our regulations 13A cited above, is deemed to have been registered, save for deregistration on any lawful grounds, including the grounds provided for in Section 9 of the Elections Act 2011. Although the respondent submitted that she was unable to find the complainant's name in the KIMS kit at the point of verification, she could not confirm whether the register being used was updated to reflect subsequent registration of voters which might have taken place. We are of the view that the absence of the complainant's name in the register that was used by the respondent could not have been taken as conclusive proof of lack of registration of the complainant. More so given that the complainant had indicated that he was registered in a different constituency. We are aware of the technological challenges which might result in a delay in real-time update of the KIMS kit, especially where registration process is conducted in different areas using different BVR machines. In our circumstances as a country, we must be alive to certain constraints that inhibit the regular and continuous updating of our register of voters, principally being limited or inadequate financial resources which affect the Commission's effective discharge of its obligations under Section 8 of the Elections Act 2011. For the process of continuous registration of voters and simultaneous update of the database of the register of voters to be efficient and to achieve real-time update of the register which the law envisages, the Commission requires adequate financial resources in order to redress the challenges currently being witnessed in the conduct of the process. With respect to the submissions of the second interested party, that the complainant registered after Gazette Notice number 7378 dated 16th August 2019, in which the Commission suspended the voter registration exercise in Kibra until 18th November 2019, contrary to Section 5(1)(b) of the Elections Act, which we have already read above. Registration of voters and revision of the register of voters under this act shall be carried out at all times except in the case of a by-election between the date of the declaration of the seat concerned and the date of such by-election. It's our finding that the provisions of Section 5(1)(b) of the Elections Act 2011 are exclusive to the electoral area, in our case Kibra constituency, where the by-election is to be conducted. It does not apply to other constituencies where there are no by-elections, and neither does it apply to registration of candidates. It's limited to registration of voters. There was therefore no impediment for the complainant being registered in any other constituency which was not subject to the by-election. It's our further finding that importing the limitations envisaged in Section 5(1)(b) of the Elections Act 2011 to the criteria set out in Section 24 of the Elections Act would amount to legislating a limitation to candidature which does not exist in law or the Constitution, particularly Articles 83.3 as read with Articles 38, 24.1, 259.1, and 259.1. Article 83.3 of the Constitution decrees that administrative arrangements for the registration of voters and the conduct of elections shall be designed to facilitate and shall not deny an eligible citizen the right to vote or stand for election. They ought to be facilitative and not restrictive. Further, Article 24 of the Constitution on the limitation of a right or a fundamental freedom provides that a right or a fundamental freedom in the Bill of Rights shall not be limited except by law, and then only to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom, taking into account all relevant factors. And that a legislation limiting a right or a fundamental freedom shall not be construed as limiting the right or a fundamental freedom unless the provision is clear and specific about the right or freedom to be limited and the nature and extent of the limitation, and shall not limit the right or fundamental freedom so far as to derogate from its core and essential content. Conclusion: from the foregoing reasons, we come to the following conclusion and issue the following orders. 1, or A, the complainant is duly registered as a voter. B, the respondent's decision of 10 September 2019 declining the nomination of the complainant on account that he was not registered as a voter is hereby set aside. C, the respondent is hereby ordered to process the complainant's application for nomination as the Jubilee Party's candidate for the Kibra constituency by-election slated for 7th November 2019 in accordance with the law. Each party shall bear their own costs. That is the decision of the... Thank you. That's our decision signed by all the three of us. And copies will be available to all the parties who participated.
We thank you for the complainant, and we are most obliged for that reasoned decision. It's one of the directions we thought you have already granted is that we are requesting for copies of the decision.
Yes.
We are also aware that the respondent is present with us here, and their complainant is with us here. If the Commission could therefore give a consequential direction that they proceed either within these premises or at an appropriate place to complete the process. As you can imagine, every day that goes the electoral process, it's a case where a race has begun and somebody has been held back for a while. We can't afford to lose one more second. So if you could direct that she accepts the papers and goes through them, satisfies herself, and where satisfied, issues the certificate to allow the complainant to pick up the race which he had been held up for his takes note of his own, would highly appreciate.
Yeah, I believe one of our orders is clear that the respondent, I think order number B, I believe the orders should apply immediately and the respondent should proceed to deal with the matter.
No,
I'm sure consultation will be made with the parties
There's
involved.
mutuality of understanding of
Yes,
that, we have no problem with it.
yes. Thank you very much.
Honorable Chair, maybe
Yes.
if just one more request, if you kindly get copies of the proceedings of the dispute resolution.
Yes, ensure that the proceedings are supplied to council within next 24 hours. Yes, certified proceedings will be supplied.
Much obliged.
Thank you.
The decisions, or as per the decision that has been arrived at by the IEBC Dispute Resolutions Tribunal, is that McDonald Mariga has been cleared to vie for the Kibra by-election that is upcoming on the 7th of November this year. And of course, there's been reference to precedents and pieces of legislation that the Commission has actually relied on to arrive at this decision. It therefore means that right now he will be processed as an aspirant and then hand over his nomination papers to IEBC, who are expected. The returning officer, Kibra, from IEBC, that is Beatrice Muli, is expected to clear him to become a candidate for Jubilee in the upcoming November 7th by-election. That is the recent development from the anniversary towers today. It is MacDonald Mariga for the Jubilee Party in the upcoming Kibra by-election. Now, we also need to establish images that we are getting live from the Supreme Court. This day, the highest court in the land is expected to give direction over legal matters or legal issues that arise courtesy of the Division of Revenue Allocation Bill. This matter found itself at the Supreme Court this year, whilst governors through the Council of Governors went to the Supreme Court to just seek legal advice on some of the issues that have ensued courtesy of this piece of legislation. And it is not the first time that it's actually going to the Supreme Court. In 2013, we had the same happen. Where the then Willie Mutunga-led bench did rule and give its advisory on this matter. But flash forward to 2019, we are back to the courts again. What advisory opinion will be given this time around? Will it rely in any way on the decision that was rendered on an advisory capacity by the same court in 2013? Well, we are monitoring the events in this place, and we shall let you know as and when we've got a substantial update. Would like, however, to bring in our reporter Franklin Masharia. He has been at the Milimani Law Court following up on the Top Cohen's murder probe. And thank you so much for joining us, Franklin. Just update us on what has happened in the courts and as far as this case is concerned.
A bad day for Sarah Wairimo, the lady who was married to Top Cohen. Not much progress has been made on her case, and today she appeared before Justice Jesse Lesit, and some of the issues that were being looked at is her bail terms and probably whether a psychiatric test had already been done on her, and unfortunately none of those has proceeded because no psychiatric test has been done on her, and the Justice Lesit has ruled or has given a directive that it should be done, and she should be taken, or she should come back to court on the 26th of this month so that she can take her plea and also just look at the issue of whether the psychiatric test has already been carried out on her. The other issue was the issue of carrying out a post-mortem on the late Top Cohen, and that is supposed to take place tomorrow. It was supposed to take place this afternoon, but according to Wairimo's lawyer, Philip Murgo, he says that Wairimo was not involved in the whole of this process, and therefore that process cannot take place this afternoon, but it will take place tomorrow, and that will establish the cause of the death of the late Cohen, and then from there it will be clear whether Wairimo should take plea or not. The Justice Lesit has also talked about other issues, including the issue of the estate that the late Cohen left behind, and some of the journalists or some of the publications have already talked to some of the family members who claim that Wairimo should not get anything or should not get any property that was left behind by the late Cohen. And Justice Lesit has given a directive that the media should not publish anything out of the courtroom. It should not publish information that is getting from detectives who are investigating this case, but everything that is published about this case should come from the courtroom. Justice Lesit saying that even the family members of the people involved in this case should also not be talking to the media about the same. So Sarah Wairimo Cohen will be in police custody for the next 10 days. Post-mortem be carried out tomorrow, and we are still not sure about the date of the burial of the late Top Cohen. He was supposed to be buried tomorrow. That is according to Patrick Miruri. This is the former MP for Gatundu and a close ally of the late Cohen, But according to the defense lawyer, Philip Murgo, he says that even the burial process, Wairimu should be involved. But Wairimu, because Wairimu was the wife of the late Cohen, and therefore anything that has to do with the burial of the late husband, she should be involved. And that is why we are not very sure probably how long this will take, bearing in mind that the taking of plea will take another 10 days, and whether the family of the late Cohen will want Wairimu to be involved in this whole matter. So another 10 days for Wairimu in the police cells, and then from there next week we will see the direction that this case will take. Njoroge.
Thank you so much, Franklin Masharia, for that update live from the Milimani Law Courts. Your take home in as far as this story is concerned is that one, Sarah Wairimu Kamotho remains in custody for the next 2 days. Not 2 days, but 10 days, I beg your pardon. And number two, their post-mortem that was supposed to be conducted this afternoon will actually be conducted tomorrow. And of course, it remains unclear as to when Tob Cohen will be buried. As per the family, they intimate that his wishes were he be buried within 48 hours. But courtesy of what has been happening in as far as this murder probe is concerned, well, that may not actually happen. But we will get more updates from the family as and when they're ready to address us and shed light on this matter. But the key story, the key highlight of the hour as of now is that McDonald Mariga has been cleared to vie for the Kibra by-election on a Jubilee ticket. Now, this has been arrived at after a decision has been rendered by the IEBC's Dispute Resolution Committee, chaired by IEBC Chairman, that is Wafula Chebukati. A lot has been said in as far as this particular issue is concerned. They have made citation to legislation and even precedents that has led them to arrive at this decision. But we